It was the first time in Dutch history, I think, that a formal apology was enforced upon the Dutch government to give to the victims. And in this case, this involved the victims of widows of men, civilians, so not soldiers, but Indonesian men who were executed by Dutch soldiers in the period 46-49. And euphemistically, in the Dutch discourse, we use it police actions, like it was an internal affair that had to be, you know, toned down. No, we're now finally starting to address it as a colonial war, which it was.
Indigenous peoples, and you see this through various UN documents, don't talk about decolonisation. For these communities, decolonisation hasn't happened. Yeah. So this idea of decolonisation being an incomplete process and indeed independence not being gained by them, and this is why they emphasise the idea of the right to self-determination, their ability to determine how and in what capacity their cultures can develop and be accessed by others, certainly. When we deal with cultural loss with Indigenous peoples, it is very, very much a whole of community, whole of person claim. So, and there's a reason why it's significant. So when cultures and their disappearance through destruction and assimilation, as I said, was central to the colonial process, and specifically nation building by settler states, this had a particularly devastating impact on Indigenous peoples because of the way that they understand culture. This is the law specifically refers to compensation as monetary compensation, is only to be addressed when restitution is not possible, yeah, or making reparations complete.
I'm not going to deal with the CARICOM case in its entirety, so I'm not going to be dealing today with the whole question of reparations for slavery and native genocide. I'm going to be focusing on one aspect of the claim. And that aspect is actually the full title for the CARICOM claim for reparations is actually reparations for slavery and native genocide. And if we look at the 10-point plan for reparations, we see that in point 3 of the plan, specific reference is made to Indigenous peoples development and Indigenous peoples development programme. Traditionally, reparations for Indigenous people can be afforded by two main legal means. The first is a state-on-state approach, and which is what we're seeing here in the CARICOM claim. And the second is a human rights claim, so a claim being brought by a citizen against the state. And of course, the second approach is the result of this gradual evolution of international law to being based on solely between the rights of states and the obligations between them, to also including the rights of individuals and the obligations of states towards their own citizens. So Federico Lenzerini he's written a book on reparations for Indigenous peoples, and he argues that there's also a third way in which reparations for Indigenous peoples can be envisaged in international law, and that evolves from, or it contains a type of relationship that's similar to the relationship between states, and it's obviously much rarer and more exceptional because it's based on the premise that Indigenous peoples never lost sovereignty over their ancestral lands. So treaties concluded between native peoples and colonizers are often considered probative of such sovereignty. And in the US, for example, we can see that between 1787 and 1871, over 650 treaties were signed between the federal government and Native American tribes, and many of these treaties are considered legally binding as well today.
If reparatory justice engages with a time not yet past that continues to disfigure the present and foreclose the future, how then is the legal approach related to a philosophy of history that acknowledges that we cannot know, but only can approach the past from many different perspectives and with the help of an endless kind of sources? And I would plea for a real historical approach to issues of redress in terms of thinking about the future and not in legal terms. From a historical point of view, I would like to take as my position a dedicated anti-essentialist take on any discussion on reparatory justice, redress, and compensation. Some, however, also severely critique the dominant approach to ancient history as such, A historiography of which the Palmyra statue in Edinburgh might be an expression as well. And this happened, for instance, when students and their organizations organized a major debate on the Eurocentric approach to ancient history, and in their view, the systematic denial of the impact of African civilization and African presence in our teaching on the past Greek-Roman society. I started to discuss the discussion in my university on antiquity studies, because you can see that there are so many different layers of time and relationships to time between all the stakeholders, and moreover that the sources and the resources change meaning themselves. Then I discussed this division between inheritors and beneficiaries of historical injustice, and I would say that the legal approach which requires institutions and individuals to be responsible or to get an answer, in a way, also are those who are the result of this colonial past and can be reinforced in this whole process.
Now, why did I develop a model? Perhaps because I was thinking that discussions about transitional justice or about restitution or about reparations were suffering from many good intentions and not so much theory, not so much vision. And people have all kinds of nice ideas. Sometimes they are fit well together, sometimes they are in contradiction with each other. And I didn't like the way people were putting forward programs without a clear vision on the limitations and possibilities of each approach. This is about time frames. So in each approach, one time frame is dominant. For example, when you are trying to forget the past, the present is the dominant time frame and the past is neglected. In the next phase, justice, the past is the dominant time frame and the future is neglected. And in the reconciliation frame, the future is the dominant time frame and the present is neglected, and that's also why there is this sequence. Legally, the struggle, for example, in the CARICOM claim, it is about trying to demolish legal instruments, legal ways to keep the past in the past, just attacking statutes of limitation, etc. But also by legal arguments. So you need legal arguments to show that it is necessary to counter legal principles that are trying to keep the past in the past. And one important argument is countering the argument that it has been legal at the time. For example, with regard to enslavement, the British government is saying, well, it has been legal at the time, so we cannot help to do, and we cannot do anything about it.